Almighty God, we invite your presence. We ask you to reign over us in our deliberations in the interest of our country and our people. In Jesus' name, amen.
Thank you very much, Senator. First of all, let me apologize for the chairman who is unavoidably absent. He, as tourism minister, he does a fair amount of traveling to secure tourists for Jamaica, no doubt. Welcome to all the members. The membership consists of how many? There are 15 members. And I would say that, in future meetings, a quorum would be for the chairman plus 3 others, 4?
Well, for joint select, you choose your quorum, so it can be whatever number you wish. It is usually suggested that 3 at minimum because, sometimes you can't get members to come.
Quite. So may I ask members to make a recommendation? The quorum, the recommendation is usually the chairman and 3 others. So it's really 4. So from the 15 members, agreed? Agreed. Now, welcome to those who are here. We have apologies from Dr. Maurice Guy and Ms. Tova Hamilton. May I just indicate from the very beginning that there's an understanding that the members of the committee will be the same as those who will also be a part of the Integrity Commission review. Sorry? No?
I believe there are 2 of us from the Senate who is not on that committee, myself and Senator Brown. I don't know why they want to separate us, but they want us to have independent thoughts, maybe.
Okay, all right. The position anyway is, let's deal with this particular, the Protected Disclosure Bill, Act itself. Now, as you can see, this act was enacted in 2011. And one of the understanding was that after 3 years, there would have been a review, if you look at section 27. So the review should have taken place from about 2014. But for one reason or another, no review had been taken. So the opportunity was now taken for this review to take place. Colleagues, just a brief opening remarks, and then I will ask members to make their own comments. This Protected Disclosure Act, to the best of my knowledge, has not been well utilized. And one of the reasons, perhaps, is that it is not well known. But the idea behind this Protected Disclosure Act is for the general public at large, but more in particular, persons who work within the public sector, to be able to disclose any, and to use the familiar Jamaican term, any hanky-panky that is going on within the public sector. But moreover, to persons of integrity within the public sector who see acts of corruption or acts of inappropriate dealings, that they can bring it to the attention of the proper authorities without fear or possibility, should put it no stronger than that, of being affected in their employment or to suffer any detriment from disclosing, the fact that they have informed. Quite frankly, the act itself is a very important act because when things go wrong within the cloisters of the public sector, unless persons are aware and can properly disclose inappropriate conduct, then not many people will be aware of the misconduct the corruption or any other inappropriate conduct within the public sector. So this act itself should really have been promoted thoroughly over the years, but for one reason or another, it has not been promoted. Now, only last year, I think it was, the Integrity Commission did approach me to make them to be the enabling body so that they can promote it, so that this act should be utilized more effectively. So we expect that, once we do the review of the act, there may be addition, there may be subtraction as we decide or as the public at large sees fit to make their presentations, that the personnel, the public, not only persons in the public sector who can disclose and feel free to do so without the possibility of being charged, dismissed, or suffer any detriment. But in the same way, persons who deal with personnel in the public sector and who are aware that persons in the public sector are demanding payment or demanding bribes, to put it no less than that they can in fact report it to the proper authorities. Because it may well be that there are persons within various agencies, departments, or ministries who, in order for anyone to get a benefit, be it a license or a contract, or even to expedite their requests or their applications for things, that they feel that there are persons who they have to pay in order to get things done. And you hear these, should I put it no stronger than this, anecdotal information that they can't get anything done unless they deal with certain persons or they have to pay a certain amount. Truth of the matter is that if we are going to fight corruption, then we definitely need to expose and to prevent matters like this. Because with due respect, a lot of people get blamed. For instance, let us say as minister, I get blamed for everything that happens in the courts. And I don't even know what is happening. So if things are happening in the courts, then in all sincerity, if it is wrong, it needs to be exposed. And this is what this Protective Disclosure Act is meant to do. To give you another example, every opportunity I get at the Commissioning of Justice of the Peace, I emphasize that it's a voluntary service and justice of the peace must not charge. But then you have persons who, for one reason or another, solicit from persons who need a recommendation or need a photograph witness, who actually charge. Now, quite frankly, we have been successful in identifying some justices of the peace who inappropriately are demanding payment. And in those circumstances, we have been able to warn these people, and in a few cases where we can prove it at disciplinary committee meetings, to decommission those persons. So, colleagues, those are my opening comments. We hope that we're going to invite members of the public, certain definitely organizations, to look at this bill and to make contributions and appear before us early next year to see how best we can improve this particular bill. Those are my opening comments. Yes, Member Robbins.
I think the issues go a little bit beyond just lack of knowledge of the bill. I think we also have to deal with the issue of the Official Secrets Act, because in cases, there have been cases where persons may want to say something, are inclined to say something, but there's this view, or it may be more perception than reality, that if they do so, they would be in breach of the Official Secrets Act. And we have had cases where issues have arisen of potential and real impropriety, and that has been, quote unquote, waved over people's head. So I think there has to be, in conjunction with this committee looking at amendments to the bill, some public education around what the merits of this bill are, and also what the Official Secrets Act covers and what it doesn't. Because I know that is also a deterrent to people speaking.
Yeah. Chairman, your opening remarks point this legislation to the public sector, but in its title, it spoke about public interest, and we could make the narrative be that the public sector is the only place that corruption takes place. The legislation, I believe, doesn't limit it to the public sector, because private sector, as some people say, for every bribe, you have a briber. So the issue of does this legislation apply to the private sector, and the provisions and protection afforded to employees that extended to them as well. I'd like to recommend, Chairman, that as we review this, and I'm disappointed that the enabling agency, the implementing agency, the Integrity Commission, isn't present for this session, because just as...
I don't necessarily think they were invited, for example.
They might not have been.
Because this meeting was meant to be a very short meeting,
Yeah.
to deal with procedural matters. But certainly at the first meeting, when the committee reconvened, they would be invited.
And it's not a criticism of them. It's just simply thinking that, because I want to recommend that we look at some of the best practices internationally, including, for example, the EU directive. It doesn't bind us, but certainly it's something that would help us to see how they who developed this legislation before us, and again, so we modeled this legislation, the United Kingdom, how it applied, and just was looking at what they did and how they have modernized and improved their legislation. And this is something that whoever is going to do the research could look and share with us, so we may benefit from where they are at. And as I said, this ought not to be a public sector only. Corruption takes place in the private sector. Health issues, and issues like those impact the public sector. Are they cheating on regulations so that people would know this? I mean, it's just difficult, Chairman, not to mention the candle factory in Kentucky, in which I told the people, don't go home in the face of a tornado warning, and we saw what happened there. So the health and safety of workers would be important in private sector company for people to disclose what is taking place, along with the public sector where it is well known.
Mr. Chairman, Golden Campbell, I was simply trying to, I just wanted to kind of refocus on the procedural issues for today, because I think we may be getting into some substantive matters. We've decided the quorum to be 4. I'm not sure if Chairman has other matters that should be decided in relation to procedure. Certainly, on the next occasion, we would want to be in a position to at least begin the hearing of submissions, so there needs to be some lead time, I gather.
Right. No, we're coming to that, definitely, because the main procedural matters is who do we write to invite to make submission. Not that they will, but we should write them to invite them, but also to put advertisement in the newspapers, and then to set a date or, indicate that all the submission must come in by a certain time. So we need a committee to decide. Once we meet now, we put in an advertisement over the next 2 Sundays or so, and then we can say by the end of January or the middle of January,
I would do the odds now for submissions to start first week in January, because we're in the Christmas break and you can't really expect much. And I'd give people 6 weeks, close by the middle of February, and then we can start to have the review the submissions and ask them to come and present.
Quite. Any other comments before I just finalize that? Yes. Member Holness. Okay, good point. We start again. Any other comments?
Just a suggestion, members, based on practicality over the years, what we find when committees, joint select committees, they do the ads in December, it's overlooked. Persons actually don't send submissions, and what happens, committees usually have to extend the dates over a period, because during this period, most persons are on a holiday, they don't really pay attention.
Good. Right. But let any other comment? Yes, we're going to go back to that in a second. You wanted to say something, Senator?
Yeah, I was going to talk about who we invite, because there are certain entities or the oversight committees. And also, in a situation like this, where Senator Brown has indicated that this is not confined to the public sector, because we have had the same issue of protective disclosure where you can inform in secrecy, but a legislation that was the most secretive. It wasn't announced. It wasn't, there was no promotion of it. And I'm suggesting that we should include the employer organizations to be invited. Naturally, in a situation like this, the trade unions will have a voice, and so the Confederation of Trade Unions should be invited.
Sure.
But I'm thinking about those umbrella organizations that represent both employers and employees to be invited, and inclusive of the oversight committee. The other point I want to make, because we have a parliament with a lot of joint select committees and there are competing interests, whether or not some of these joint select committees have been held virtual, and they have been very successful,
effective,
and effective. So maybe we can consider, Chair, whether or not we want to utilize the virtual settings.
All right. Okay. All right, and then, all right, so let's just make some decisions then. First, the idea is that we should advertise at the beginning of January. So for maybe the first 2 Sundays in, second and third Sunday? Second and third Sunday in January. Right. So we put in the advertisement inviting anyone to, have a look at the Protective Disclosure Act and make their comments or their contribution to the Clerk of Parliament. Yeah.
Chair, could I also ask that the committee clerk send us a soft copy of the advertisement that we could also put out on our social media pages? I'm not sure how much Parliament utilizes that as a way of getting submissions or advertising things, but certainly the members could do that. So if we could get a soft copy that we could share.
Not a problem. But then having put them out, these advertisements, We are going to close off at the middle of February. They must send in their submission by the middle of February. Well, by the middle of February, rather than say 6 weeks after. We say by the 15th of February, so whatever the middle of the 15th of February. Would that be okay?
And Chairman, if when we say protective disclosure,
The 14th then. Sorry.
if when we say protective disclosure, we make it clear because people understand the whistleblowing element of it. So we find a way to.
I think in the advertisement we should put in bracket, generally known as the Whistleblower Act.
Yeah.
Okay? And then, based on the submissions, I suspect that the next meeting of the committee would be at the following week, something like that. Right, 2 weeks, by the end of February, okay?
No, Minister, remember ceremonial opening and standing finance committee and budget debate.
All right, but bear in mind, my hope is that even while there are budgetary considerations, Parliament may not be meeting, but there's no reason at appropriate times the committee can't meet virtually. Because with due respect, I don't want this to go on longer than 3 to 4 months. I think by, the June, July, we should be getting rid of this act. I mean, I would hate to think that this has taken so long to review. It is not a very extensive act. I would hope that, with a matter of 6, 8, joint select committee meetings, we can report and then have a review and that it can be done quickly. No, fair enough.
So, Minister, the first decision we have to make is about whether we're going to meet virtually.
No, yes, and I think there's an understanding.
We had done that?
So we literally need to vote to meet virtually, so it's recorded for Hanson, and we need to do that today because it will need to come to Parliament this afternoon. Remember, we go on recess today.
Right.
And we still come back to our committee meeting physically
To be fair, though, I remember.
before we can start meeting virtually.
Right, but to be fair, though, I remember. Right, if we agree to meet virtually, we could do it this afternoon, yes, but we could also do it at the first. Yes. Do it.
Chair, here's the problem. When you make the decision to meet virtually now, which we would need to do now, it comes to Parliament for us to make the statement that we would like to meet virtually and have that passed. And then we are really required to come to another face-to-face session of the committee to finalize and ratify that
Okay.
we meet virtually. So we need another face-to-face session, or
We have to
can we pass in
come back
Parliament
face
and
to
then
face.
go
Just pass it. Once it's passed in Parliament, then you can meet virtually. Yes.
Okay. All right. So, can we then that decision that we can meet virtually? Are there any objections? No objection. Okay. All right. If I might just make 1 or 2 comments.
Yes, Chairman.
Yes.
There would have been a list of organizations that appeared when the bill was being discussed. And maybe we could just ask the Parliament to look back at those, and that could be an aid. I recall representing the unions at that joint select committee.
Sure.
Yes.
Put it differently. The list is not exhaustive. So we would just ask the committee secretary to write as many of these organizations. Believe me, when we did the NIDS bill, we wrote close to, I don't remember, quite a lot. Over 100. So we just send them an email because we have their email. So we just send it by email, send a copy of the bill, in bracket Whistleblower Act, and ask if they would like to make a contribution to the Joint Select Committee. Okay? So we would send that. There are certain institutions that you normally send to, like as you say, we must make sure the employers, the trade unions, the the Norman Mandela Law School, Faculty of Law, the Jamaica Bar Association, General Legal, etc., etc. We have to stop no. But just
Chair,
one or two, sorry.
Just want to add to that, I don't know if it would normally be on the list, but the Office of the Services Commission could also be on that list.
Sure, sure. Now, just one brief comment. During the deliberations, we can make recommendations in relation to the Official Secrets Act. That's all we can do, make recommendations. I agree with you, Senator Brown and Senator Gale, that corruption is not only in the public sector. Indeed, most of the beneficiaries of the corruption are in the private sector, and oftentimes they're the ones who initiate it. But the truth of the matter is that oftentimes within the private sector, they're dealt with differently, you know, and they're charged, if found, criminally, right? So.
Chair, I'd be grateful if the committee clerk would ensure that we also had hard copies of the Official Secrets Act. We couldn't get those.
That might be a good idea. All right, so there's one other thing the quorum is for. Yeah. And I think the legal officer is saying that we are to elect a chairman.
Right. So,
yeah, so.
Standing order 76-2.
Well, as
Not elect a chairman. So though we know that Minister Bartlett is who is being put forward,
yeah.
he wasn't elected in the House. And so at this joint select committee, we all...
All right. Well, as acting chairman, I do move for Minister Bartlett to be the chairman. Seconded? Any objection?
So seconded, Chair.
No objection. Very well. Can recommittal of apologies?
Dr. Guy.
I did mention. I did mention.
I believe Madam Attorney General had also issued apologies.
All right. Can I ask some motion of adjournment, please? Sorry.
Sorry, Chairman. Jeffrey Foreman, Attorney General's Chambers.
Sorry, I'm sorry. I should have welcomed the Attorney General's Chambers, Mr. Foreman, and also to indicate to you that the Legal Reform Department was informed that they will be required at the sit-ins, and also, as Senator Brown has pointed out, that I did intimate to them that they could give us some best practice on this particular, not only this, the Integrity Commission bill, when we get to that. And I think we'll also have officers from the Ministry of Justice at these meetings too.
Chairman, one more point before you go, Chairman.
Sorry, let me ask Mr. Foreman. You finished, Mr. Foreman?
No, I just wanted to say that the representatives from the LRD and the Office of the Parliamentary Council asked me to apologize on their behalf.
Right, they will be invited to all the meeting.
That I'm here representing them as well.
Thank you, Mr. Foreman. Sorry.
Just one more point, Chairman. The list is fairly exhaustive. Could you have the list emailed to the committee so that if we identify an organization, institution that is not present there, we would be able to make those recommendations?
Okay. Right, because, I mean, the Parliament has a huge list. As I said, we invite over 100, and maybe 20, 30 of them do respond. So thanks again, members. Motion for adjournment of this meeting. The Joint Select Committee on the Protective Disclosure Act is now adjourned to a date to be fixed. All right. It was moved and seconded, yes. It was. It was.
Yo!